Good morning. We will now convene this meeting of the Labor and Public Employees Committee. And I will start out by just saying we have an agenda with 12 items today. I think they're all important, and I look forward to a good discussion and getting the work done. Any comments from the ranking members? Nope. Senator Sampson? Representative Weir. Great, then we'll just begin. So the first item on the agenda is Senate Bill 268, an act authorizing the comptroller to withhold payment for violations of the prevailing wage statutes. And this is a JF to the floor. Are there any? And I think we've heard this bill before. We've talked about it in committee when we raised the concept, and we've also had testimony on it. This is the same bill as last year, which would, with some minor changes, but I think they were important to some people, to make sure that when the labor commissioner issues a stop work order at her discretion, she may refer to the comptroller the stop work order and request for stop payment. There is a notification process in there for the employer, and the employer is given an opportunity to remedy the situation, and if they don't, the comptroller can stop payment. Are there any questions or comments on this bill? Senator Sampson.
Okay, that button works. Good morning, Madam Chairman. Thank you for describing the bill in short form anyway, and I would appreciate it if, as we go today, that you just do a brief description of each bill as we get to them. We did debate this bill in committee last year and at some length on the Senate floor, and I do have some concerns with it. I appreciate the desire to make sure that the folks that are employed via these contracts are properly compensated. I mean, that's obvious. We all want to make sure people get paid for the work that they do. But I think that there's a few issues here that I think people should consider as we debate this proposed bill. And that is, first and foremost, that, this can only happen in a government situation. In a private arrangement, where you have a contractor and subcontractors and employees of those various entities, there has to be some sort of litigation in order for people to withhold payment. You wouldn't, even in a contract dispute, you would not withhold payment from the subcontractors without having some sort of mechanism to do so, either preordained in the contract itself or through some sort of notice or litigation process. So that's my first question, really, which is why do we want to make it so that the state can unilaterally choose to first determine whether or not a stop work order should exist, because this is a process that is done unilaterally by the Labor Department based on the opinions of the Commissioner of the Department of Labor. And then second of all, she has complete and utter discretion about whether or not to bring the issue forward. And ultimately, the comptroller has discretion once again later on in the bill. But the basic question to start with is, why is the state of Connecticut special? I guess is the question I have. Why should the state of Connecticut have the ability to do something that no private contractor can do? Through you, Madam Chairman.
Thank you. I would answer by saying that I believe that the state of Connecticut should always be in a position to be the best employer, the best protector of workers in our state. And I can't understand why we as a state would pay any contractor who is violating the law. And you're correct that this is done by the Department of Labor, but the Department of Labor are the experts. We empower them to do these investigations, to issue the stop work orders, and this is adding another mechanism, a tool, someone would say, to make sure that we are addressing these problems more quickly. When you're a worker on a project and you're not getting paid properly, God forbid there should be some accident and you didn't have workers' comp paid into, so you're not protected. These are things that should be remedied as quickly as possible. Senator Sampson.
Thank you for that response, Madam Chairman. And I appreciate your comments. And, you know, it sounds very good, but it's also a little bit revealing in the sense that you refer to, you know, I think violating the law is a term that you used. In this particular bill, who determines who violates the law? The state does. You know, it's like it's almost like, you know, the state is the judge and jury throughout the entire process, and with complete and utter discretion on who to apply to this to and who not to. You know, I have a big concern about a shift in our society between the written law, where it is written clearly, it is defined in a way that everyone knows what it means, and that it applies to everyone equally. That's the way our laws should be written. In this particular case, we are writing a law that effectively says that the Department of Labor can unilaterally make a determination that someone is in violation, and then they can have complete discretion on whether or not to apply that law. So what if it's a friend of the governor's who's the contractor in question? Maybe the Department of Labor commissioner doesn't apply the law in that particular case. That's what this bill allows. If it's someone that the political establishment feels is hostile, then they can maybe apply the law in more cases. We have to remember that what we're dealing here with is not private entities working based on merit. What we're dealing with is political entities. We're talking about a labor commissioner who's a fine person. I have no issue with her. But down the road, who knows who our labor commissioner is? That labor commissioner is a public appointment of a political entity. That's who they are. And that means that if you give them discretion, they can use that discretion in any way they choose. And they can use it in a political way. And they can do it lawfully under the language that is in this bill. This is the danger of what we're creating here. Is on one hand, we are getting away from the rule of law, where it applies equally to every person, but we're also creating a mechanism where we're empowering individuals, kings, basically. You know, I hear no kings all the time, but this is what this is. We're creating several kings in this bill. We're creating the king of the Department of Labor commissioner, who gets to arbitrarily decide when to put a stop work order in place, which I understand the purpose of that and may be the only mechanism that we have. But they have complete discretion. And then we're also creating the comptroller to have a complete discretion on how to apply the law. So can I ask why, through you, Madam Chairman, why we've used we'll do these one at a time. In line 65, why is it that the labor commissioner, it says after issuing a stop work order, the commissioner may, M-A-Y, notify the comptroller. And folks that follow the legislature know very well that the words may and shall show up a lot of time in our statutes, and they're always on purpose. So this is a purposeful may. Why does it say may? Why are we giving the discretion to apply this statute in some cases but not in others to the labor commissioner? Through you.
Thank you for the question. I believe that the intention of putting the word may in there is to allow the commissioner to have discretion, as you've pointed out, and not do this in every case. And the reason for that, I believe, is there could be an instance where the Labor Department is working with a contractor to clear up the violation, and they feel that they're making a good faith effort to do so, and they would not proceed to the next step to ask for the stop work order. I believe that discretion is there to help those contractors who are trying to do the right thing, but maybe have had some problems on their end. However, I will say this, that if you feel strongly if this is something needs to be addressed and that we should take away that discretion, I think we could continue to talk about that, and this could be JF today, and we can continue to talk about removing discretion and making it an absolute on the part of the commissioner and on the part of the comptroller, if that would address your concerns. And, you know, we could entertain that as an amendment on the floor.
Thank you very much, Madam Chairman, and I appreciate that offer very much. And I appreciated the first portion of your answer, which is a good thing, you know, that there could be a circumstance where the labor commissioner is trying to work with a particular contractor and they don't want to immediately, you know, put the hammer down necessarily. And that's fine, except that it's awful arbitrary. And in my view, what we ought to do is remove the discretion and cite the reasons or some sort of definitions that would enable that process to be paused, something of that nature. I do not want to leave arbitrary discretion in the hands of a political appointee. That's what I don't want to do. Because, as I mentioned earlier, while the point the good chairman made about this could be a perfectly legitimate situation where the commissioner is acting in good faith to try and work with the parties, it also could be for political reasons. And in fact, we're enabling it by creating a statute that just gives them discretion. They can use whatever reasons they want if we put that in the statute in that form. So that is a concern of mine. And I'm not referring to this labor commissioner or anyone in the future. I just say that the possibility exists. We don't know who will be in our state government participating in the future. And I think that it's imperative that when we write statute, that we make it very clear to all the parties, particularly entities who want to do business with the state of Connecticut, what their expectations are. And to set them up with an expectation that says that the commissioner can arbitrarily decide whether or not to issue a stop work order to begin with, but then whether or not they will go ahead and also try and stop payment. I noticed that it says that they may notify the comptroller, as we talked about, but there's also no time limit. Is there a reason why there's no time limit in paragraph D1, line 63 to 68 through you?
Thank you for the question. I believe that the process of working with a particular contractor about addressing the violation could take longer or shorter time. So we are allowing for the Department of Labor to have adequate time to address the issue and to investigate thoroughly and look for solutions. I do want to address another issue you raised in your opening comments about this is being applied only to government and not to private development jobs. And I think that we could address that too in future years if that's something that you think needs to be addressed. We see workers' comp violations, not prevailing wage. This bill is specifically about prevailing wage violations, which includes workers' comp payments. But we see that on private jobs as well. And it's of great concern. It's concern of the safety of the workers that are on that job, that they're not covered by workers' comp. And I could see in the future, if it was to your liking, that we could move forward and look to also have the same provisions apply for stop work orders on private jobs if they pertain to the non-payment of workers' compensation. So I think that, prevailing wage jobs are jobs that we have more authority over because we're paying for those jobs. They're jobs that the state is making payment on. So it seems like that would be a good place to start to make sure that we are a good employer, that we are investing taxpayer dollars in ways that are not harmful to workers who are working on those projects. But I think that we also have responsibility in the private sector to make sure that workers are safe. And so if that was something that we could work on in the future, I'd be happy to work with you on that.
Thank you very much, Madam Chairman. I have a lot of things to respond to. You had a lot in that dialogue. I guess I want to be very clear that I'm very much in favor of the spirit of the bill, which is the idea that we want to protect folks that are operating across Connecticut in various, contractor-related infrastructure development. You name it. Some of these job sites are dangerous. If the stop work order is issued for legitimate reasons, then certainly we want to make sure that it's adjudicated properly. My focus today is on clarity. It is setting up the rules of the game in a way that they're very clear to all the participants, so that there's no arbitrary decision making along the way in the process. I also part of me is looking at this like, oh yes, this is a great bill because what it's going to do is it's going to protect taxpayer dollars in certain cases when they're being abused by creating this mechanism for the labor commissioner and the comptroller to work in tandem to prevent these payments. But again, it's all about prevailing wage, which if you were actually concerned about taxpayer dollars, you wouldn't have prevailing wage. Prevailing wage is one of the most significant things hurting our state local property taxpayers. I mean, towns are forced to pay upwards of 2 and 3 times for projects. School roof, for example, or something like that might cost exponentially more than without prevailing wage, and we're all being forced to pay for it with some of the highest property taxes in the country. So, to protect prevailing wage to me is something that I'm loath to do, but it is the law of the land, and I respect that. And I do want to find my way to a yes on this bill. But what I want to do is make sure that we clean up this language to remove any of the arbitrary decision-making that happens along the way. So following the concern that I already made about the labor commissioner being able to decide whether or not they want to enforce this provision with this may that is in line 65, we then move to the comptroller's responsibilities. And the comptroller doesn't have such latitude about notifying the contractor. On line 71 it says the comptroller rather shall notify the contractor, which is fine. But again, I just pointing out that we're choosing mays and shalls along the way in this bill, and we're doing it for certain reasons. And then on line 73, the contractor or subcontractor shall comply. We're not leaving it up to them clearly. Although, in a private sector dispute, the parties are obligated to live up to the contract. If one of the parties is in violation of the contract, fine, but you have to go through some sort of litigation before you can suddenly decide that you're going to stop paying someone or walk off a job site. This is putting the state in an entirely different situation where they can just, on a one-sided, arbitrary decision, which is entirely up to the parties that represent the state side of the equation to go forward with or not. And then we return to the comptrollers now got the full responsibility of deciding whether or not they're going to withhold the payment, and that's in the paragraph 3 starting on line 76 through the end of the proposed bill, line 83. And this says the comptroller may, again, withhold payment. Look, if the stop payment actually occurred because the labor commissioner had a legitimate reason to do so, and then they've been notified, shall be notified, and the contractor shall comply. Well, if they don't, I don't see why we have a may at the end. So why is this a may? Through you, Madam Chairman.
Thank you. Again, I believe that the reason why there are deadlines on the comptroller is because he is not the person adjudicating this. We're not giving him that authority. He's simply required to notify the employer and do that on a timely basis, and then after that notification to give the employer another 10 days to comply. If they don't, however, we give him some discretion after that for the same reason I think we gave it to the DOL commissioner, not to adjudicate the situation, but if the comptroller's office is in conversation with the contractor and the contractor says, I can get this done, I can't get it done in 10 days, but I could get it done in 11 days, I think that we have the may there for that reason. But I will say that if it was possible to get to a yes on this, I think there will be time to have further discussion after this meeting, after we JF this bill, which I assume we're going to do today, to have those conversations. I'm not sure that it will actually be helpful to change those to directives instead of giving discretion to the comptroller and the commissioner, but I think it's worth a conversation, so I'd be happy to have that.
Thank you very much, Madam Chairman. I appreciate that response and that offer, and I'll come back to that in just a second. The only thing I would point out is that in this final paragraph, we are giving the comptroller the ultimate discretion. We've already determined that a stop work order is in place. We've already notified the contractor that they shall comply. So it's puzzling to me to have a may in this particular case. Again, there could be a legitimate reason. There could be this conversation going on with the contractor as was described. That's fine. If we're going to do that, let's specify that. Even better, let's enable a third party that is not part of the negotiation or this contractual obligation to intervene, just like we would have a court in a normal circumstance. I don't know why we would consider this relationship between the state and a contractor different than a private entity employing a contractor. So we are giving that comptroller ultimate authority to decide, simply with a may. And again, there's no limitations. When we say in statute the labor commissioner may do something or may not do something, and we say that the comptroller may or may not, there's no limitations. We are actually enabling them to do things that most people would think are completely unethical or even illegal, but they wouldn't be illegal anymore because we're legalizing that discretion. For me, discretion should exist in situations that also have clarity about the obligations of the parties. This does not outline the reasons why the labor commissioner or the comptroller should have discretion. If we could put that into the bill, that they shall notify the comptroller or they shall withhold payment except for some circumstances, I think I would feel much more comfortable about it. And the ultimate solution, as I mentioned, is a third party that actually makes these determinations. So with that, Madam Chairman, I appreciate the offer to work on the bill. I would like to get to a yes. I do think this is an important concept, and as I mentioned from the outset, I agree with the goal here, which is to make sure that we're enforcing contracts and making sure that we properly pay people that deserve it, and we don't pay people that don't. That's obvious. I think we should all work to those goals. But it is my job, to point out what I feel are shortcomings in the language. And I really do appreciate your desire to work with me to find solutions to those concerns. And I will look forward to doing that. I will vote no today, just to flag it for this meeting. But if we continue the conversation, maybe we can get to yes. Thank you.
Thank you, Senator Sampson. Representative Canino.
Thank you very much, Madam Chair. I have a question that was actually raised by the Connecticut Association of Builders and Contractors in their testimony, which was one that I hadn't previously thought of, but it was very interesting. So to start out, under current law, can a subcontractor be ordered, receive a stop work order for being found in violation of certain labor statutes through you?
I'm going to give you my best answer. I don't know, I am not the Commissioner of Labor, and I don't work for the DOL and never have. But I believe if a subcontractor is not paying properly, then the stop work order goes to the subcontractor, but it goes to the job. The stop work order is on the job. Now, I do know from previous conversations that doesn't mean the whole job stops. When there's a stop work order on a particular contractor, that piece of work is what stops. So I believe it's the subcontractor's work that is stopped.
Right. And so if that subcontractor's work is stopped and subject to that stop work order, then under this legislation on line 78, the comptroller may withhold payment of money to such contractor or subcontractor. However, please correct me if I'm wrong, typically in these contracts, the money flows through the contractor. So if payment is being halted in these cases, then it is being halted to the entire job. While work is being stopped just for the subcontractor, I fear that we would actually be halting the payment for the entire job, which could actually have real harm on those contractors, those other subcontractors who are working on that project that are doing the right thing, the contractor himself who's doing the right thing. However, if the subcontractor is found in violation, would then payment typically be held from the entire job through you?
I think that the stop work order would trigger a stop payment for the contractor. And as you know, there's another bill that we're taking up today that does hold contractors responsible for wage theft by their subcontractors. So in that case, if the entire payment was withheld, as you suggested, then I think, in fact, that would press the contractor to get on top of the sub and make sure that they are not committing wage theft. So I think this is part of what we're trying to address in our state. When there's wage theft, it hurts the workers, obviously, but it also hurts the state. We're not getting the taxes, we're not getting the workers' comp payments that we are entitled to as a state and that we should be getting from these bad actors. And so for me, I think that stopping payment on a contractor is critically important to say you've got to do better in vetting your subcontractors. And you are responsible for the work of these subcontractors because you're in charge. So I think there is joint liability already in statute between the contractor and the subcontractor. So I think it would apply to both.
Thank you for the response. And I'm unfortunately going to have to politely disagree here because we are holding an individual who did nothing wrong in this case, who properly paid their employees, who did their best to vet these people. Sometimes you can't always foresee the consequences of who you hire and the actions that they're going to take. And in that case, not only are we punishing that subcontractor who's now not receiving those dollars, but punishing the other subcontractors who are not receiving those dollars flowing through them. So I understand the inclination to apply pressure on a contractor, but I don't believe that that's the state's right. The role of the state is to adjudicate these matters, to levy fines, to do whatever they need to do to get the issue to be resolved. However, and I would say innocent third party is being harmed here. And I'd go even further to say that halting the project is enough. I mean, a stop work order applies plenty of pressure. It delays the project. It will almost definitely increase project costs, create a whole bunch of headaches for a contractor or a subcontractor that I believe already applies adequate pressure. And so for this reason of now, we're going to be getting into the realm of holding innocent third parties liable and accountable and harming them here. I don't share the same willingness as my ranking member to be able to come to an agreement on this. I really think that the entire idea is quite flawed, and that it would be much more appropriate for this to be handled by, as my ranking member said, a third party, a judicial body that is not party to this contract, this negotiation. And if things continue to not be paid and violations are still occurring, then the state absolutely has the ability to recoup money, to give that money to the people that it needs to be given to through a proper judicial process. So for those and other reasons, I will be a no on this today. Thank you, Madam Chair.
Other comments? Representative Weir.
Thank you, Madam Chair. And these are interesting concerns that my colleagues have brought up today. I think I have worked on this bill, heard from the advocates and also from the comptroller's office on getting to a point where this could be a yes. And I will disagree with my fellow colleague here that I may be able to get to a yes on this, but I would like to see, I think, these concerns addressed that I didn't previously have that are, I think they're valid concerns that this could be to get to a point, at least through discussion, to a point where you may have your ranking members be a yes. I'll be a no today as a flag, but I think I would like to see these, at least these two objections addressed and hopefully get to a yes. Thank you.
Thank you. I see no other hands, and so I do need a motion, and I got so excited about the conversation that we didn't move the bill item as we usually do, but I will now ask for a motion on the bill.
So moved.
And a second?
Second.
It's been moved and seconded, and so I'll ask the clerk to take a roll call vote on item number 1, Senate Bill number 268.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 1, Senate Bill 268, an act authorizing the comptroller to withhold payment for violations of the prevailing wage statutes. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez, Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No?
Representative Hall, Representative Hughes. Representative Hughes, you're muted.
Representative Hughes, I believe you're muted. Are you desiring to vote on this bill? Representative Hughes?
Representative,
Are
okay.
you planning to vote on this bill, Representative Hughes?
Yes.
Representative
I
Hughes
vote,
then?
I vote yes.
Thank you. Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Gothier, yes.
Representative Mastro Francesco, Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you. So we will be holding votes open to at least 1 hour after after we get through the items on the agenda, and when we go into recess. Going to item number 2, Senate Bill number 271, an act implementing the recommendations of the Labor Department. This is a JFS to the floor, and it's LCO number 2772. Is there a motion? It's been moved and seconded, and I believe the parties are all aware that the S language would remove lines 31 to 77. It removes a provision that would have repealed a law that requires labor organizations to file certain annual financial reports with DOL and allows members of the organization to inspect the reports. Any hands? Oh, I believe this is going on to consent, so who's going to make that? Who's going to suggest that? Senator Sampson.
Thank you very much, Madam Chairman. I'll just note that I'm very pleased that you were willing to modify this bill with the S language, remove the part of the bill that we had some concerns about. The rest is indeed acceptable to the minority party, and if there's no objections, we would offer this for a consent calendar.
Thank you. So we will start a consent calendar. Thank you, Mr. Clerk, for beginning that. Moving on to item number 3 is SB number 346, an act concerning the modification to the Governor's Workforce Council. This is a straight JF to the floor. This is a bill that we took up to address some concerns that were held by the administration about being in compliance with federal requirements. Is there a motion?
Second.
It's been moved and seconded. Senator Sampson?
Thank you very much, Madam Chairman. This is another item we would offer for the consent calendar if you were so inclined.
Thank you. Then I will ask the clerk to put this on the consent calendar. Item number 4, Senate Bill 347, an act increasing the threshold amount for felony unemployment compensation fraud. This is JF to the floor. This is a bill that would increase the current level for a felony for failure for receiving unemployment benefits, that would increase the threshold amount from $500. It would increase it to $2,000. It would still be fraud, but it would be then a misdemeanor up until you reach the point of $2,000. Any comments or questions? Representative Weir.
Thank you, Madam Chair. And we had a little more than limited conversation about this during the public hearing, some back and forth with legal aid on, well, I'll take a step back and say that this bill has been around for a few years, and I can certainly, I'll speak for myself, and what I've heard concerns from my colleagues is that regardless of the fact that the 500 hasn't kept up, and 2,000 might be more appropriate in today's day and age, the message of knowingly committing fraud and then trying to raise the bar or lower, I guess, lower the standard as to what would be considered fraud is a bad message to send, especially in today's, what we see with accusations of fraud and federal investigations and that sort of thing. It's a bad message to send. However, there is a distinction that I picked up on that is concerning to me, that we have somebody who could commit fraud but unintentionally, And I don't think anybody in this room wants to see that person who puts in for unemployment compensation and is still working and thinks they're compliant with the law and finds out they're not. To me, that's a different standard. But the way that this law or this legislation reads on line 4, the word knowingly is explicitly called out. Knowingly makes a false statement, and so I think that's where we have a difference. Excuse me here. That's where the difference comes in, and not wanting to. We don't want to penalize someone who unknowingly committed fraud. Okay, that happens all the time. There's probably laws that we all break almost every day because we may not know better. So I think the discussion needs to continue as to whether or not, number one, does the Labor Commissioner have discretion when the Labor Commissioner recognizes that a person did commit fraud, but it was done unintentionally, accidentally, unknowingly. That's different from knowingly saying, look, I know I'm doing the wrong thing, and I hope I don't get caught. To me, that is, we should not be encouraging that, making that any easier for somebody to commit. And so I'm going to be a no on this, but I think we do need to hear from the Labor Commissioner. I know we've heard from Legal Aid, who had an opinion on this, and I look forward to further discussion. And maybe that means adding a section or adding some language that separates the knowingly to the accidentally or unintentionally, rather than raising this amount. Maybe we add some language that differentiates. So those are my comments. Thank you, Madam Chair.
Thank you, and I appreciate those comments. I think that that conversation that we had back and forth with the legal services folks that were testifying was very helpful. I do want to say that the kinds of fraud that I think have been really problematic for our state and for every state have been on a large scale. And we've seen this happening across the country, particularly during COVID. There were tremendous efforts to defraud the Unemployment Trust Fund. I want to commend the Labor Department because I think they really have a very good fraud unit that goes after those bad actors, people who are doing this not because they got a job and they haven't gotten paid and they have no money to pay rent or feed their family, which is, I think, the person we're hearing about from Legal Services. I don't think Legal Services is representing people who, are committing fraud against our government and against all of us in a way that we would find objectionable. These are people who can't feed their family, and maybe, and I don't think the Department of Labor has that much discretion in these cases, but it's worth a conversation, and I'm glad to hear that you're open to that conversation. And I do think the Department of Labor would be helpful in explaining to us how we could address it. Thank you for your comments. Representative Canino.
Thank you very much, Madam Chair. And I remember during the public hearing, we heard that, while changing this from a felony to a misdemeanor won't, we heard that this won't change the fact that it is still illegal to do this. And while that is true, I believe it's proper to talk about why fraud is typically a felony. It's simple from just general theft, which is more of a crime of opportunity. It is more of, it's a method of deception with the intent to harm. It's subverting one of our greatest gifts as humans, which is to reason, to use it for deception. And it's why in Dante's Inferno we have the fraudsters and the liars and in the lowest levels of hell, because it is the subversion of one of the things that makes us the most human. It's something that should be taken very seriously, and as my good ranking member stated, there's an intent here. There's a mens rea that has to be proven in court, showing that this was done willingly and unlawfully. And I believe that there's already a certain amount of discretion that the courts can apply here, especially if it is not clear and conspicuous that there was a certain intent to defraud. Of course, we don't want to be punishing someone who is just making a simple mistake and doesn't realize what they're doing. But we really, as a state, need to take serious these crimes of intentional deception that we are seeing all too often these days, and really showing our constituents that we are taking this seriously, we are taking the treatment of their money seriously, and we will not, lighten up on these serious crimes. Thank you.
Well, I typically don't engage in a lot of debate in this committee, but I do want to say that I find the remark that the person who can't pay their rent and can't feed their family and got another minimum wage job and checked that box because they hadn't gotten paid yet by their employer, that person should be destined to the lowest place in hell. I think that might be a little extreme, and I certainly wouldn't want that for any of my constituents. I can see that I'm starting a debate, and I don't typically do that. I apologize, but I think that was a pretty intense remark you made.
I want to be very clear that I in no way meant to say that anybody who's committing any of these should be intended to the lowest steps of hell. All I'm saying is that the reason that fraud is treated very seriously, and I was using a literary analogy to show why it is taken very seriously, is because it is an intentional method of deception that really utilizes our will, our reason, our greatest gift from God for some very nefarious actions. I completely understand if there's an individual who's going through some tough times, who makes a mistake unknowingly, that we should not be coming down on them so hard. But again, like I said, when it is proven to be very intentional, they know exactly what they're doing, we should not be going light on that. So I don't want my remarks to be taken out of context. It was purely an analogy, but what I think we're doing here is very improper, and I will still be a no. Thank you.
Senator Sampson.
Thank you, Madam Chairman. I'd be delighted to back up Representative Canino's comments. The very first sentence of this includes the word knowingly. We're not talking about people that are doing things accidentally or out of desperation. These are people that are criminals. That's who we're talking about. We're talking about someone, not just criminals, but people that are willing to steal unemployment benefits. In other words, people that are willing to take benefits that are intended for other people that are actually experiencing hard times. So I don't have any sympathy for them, frankly, and I'm glad that this is a felony, and reducing it to me is absurd. We should not be being softer on crime. We have too much crime as it is. What we ought to be doing is having harsher penalties that are actually enforced. Another concern I have about this, which is maybe a tiny bit of a stretch, but changing this from a felony to a misdemeanor not only diminishes the importance of the crime and therefore diminishes the impact on that person going forward in their life, whether that shows up in a background check for a job or anything like that. Misdemeanors, we can look through the list of misdemeanors. I mean, stealing unemployment benefits from others, to me, rises to a level beyond most misdemeanors, and it ought to be treated as such. The majority party has actually already modified the misdemeanor 1-year sentence in Connecticut to actually be only 364 days. And they did that to prevent federal immigration authorities from being able to hold illegal aliens that are committing 1-year misdemeanor crimes accountable. We're going in the wrong direction, Madam Chairman. We should be going towards the rule of law. We certainly should not be diminishing the penalties for significant crimes in our state. And stealing unemployment benefits from people that are actually in need, to me, is beyond the pale. The crime the penalty should fit the crime, and I don't believe this is a good bill as a result. Thank you.
Any further comments? Seeing no hands, I will ask the clerk to call the, oh, wait a second, did I make a motion on this? Okay. I'm so excited today. I have not done this in the past, but we're really getting into these conversations. It's been moved and seconded, and I will ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 4, Senate Bill 347, an act increasing the threshold amount for felony unemployment compensation fraud. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez, Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No?
Representative Hall, Representative Hughes,
Representative Hughes votes yes.
Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Gothier, yes.
Representative Mastro Francesco,
Master Francesco votes no.
Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you, and we will be holding votes open. Next item on the agenda is item number 5, Senate Bill number 349, an act concerning modifications to the firefighters' cancer relief fund. Is there a motion?
So moved.
Is there a second? It's been moved and seconded, and this is a minor modification that would consolidate two reports into one, and also require that be reported back to the Committee of Cognizance, the Labor Committee. Senator Sampson.
Thank you, Madam Chairman. We have no objection to this bill and would gladly offer it for consent if you are so inclined.
Thank you. We will be adding this to the consent calendar. Mr. Clerk, please make that note. We'll move on to item number 6, House Bill number 5275, an act concerning a contractor's responsibility for unpaid wages on a construction contract. This is a JF to the floor. Is there a motion? It's been moved and seconded. This is a bill that would require, that would hold liable a contractor in the event they would be jointly held liable with the subcontractor for non-payment of wages or underpaying wages or violating any labor statutes on a construction contract. Senator Sampson.
Thank you very much, Madam Chairman. This is another bill that we've seen in the past. I don't know if this version is the same as we have seen in the past. For those listening, this is a pretty straightforward bill which effectively would take and make a contractor or general contractor responsible for the lack of payments made to employees by a subcontractor. And I've always objected to this bill based on the notion that why are we holding someone that is not responsible for the wrongdoing accountable? And again, it's the same theme that we continue to see in this building over and over again, which is shifting of responsibility, holding people that have actually done their job correctly accountable, making people that work hard pay for people that are willing to take advantage. And it's a frustration. I do see that on line 12 through 14 or so, we have carved out home improvement contracts and the construction, renovation, rehabilitation of an owner-occupied residence. So this is, I think, a good improvement. If it came this year or last year, I'm not sure. But at least we're going to keep innocent homeowners out of the loop, thankfully, from being held accountable when a subcontractor that they hire fails to pay their employees. I mean, to me, that was an absurdity. But it's still not much more of a stretch to say that we should be holding contractors responsible when they hire a subcontractor on a job site to do something and that subcontractor fails to pay their employees. Why are we going to punish that contractor? Why are we going to potentially end up in a situation where the job doesn't move forward, where other contractors can't operate, where they can't get paid? It could end up delaying projects and costing people a lot of money and their livelihoods, which is something that I know the chairman has expressed concern for, and I share. You know, to me, this sounds like a chain reaction. We have processes for this already. It's called litigation. When people fail to live up to the terms of a contract, we use our court system to adjudicate these matters. I see two things happening in this committee that are constant frustration. One is that we are constantly telling people what they can put in their contracts or what they cannot put in their contracts when those are free citizens out there. They're engaging in commerce of their own accord and their own free will. They should be able to put whatever they want in the contract. And for us to dictate to them what they can put in their contract, to me, is an absurdity. Who are we to step inside someone else's business arrangement, whether it is an actual, contractual agreement, for a specific job, or it's an employer-employee long-term arrangement. Either way, it's none of our business, outside of protecting children and things like that, maybe. But the other thing that I see is that we're constantly saying that those contracts don't matter, right? So you can't put this in the contract, and by the way, that part of your contract doesn't matter because we're going to go around that and hold you responsible for the failure of some other party. I don't think it's worth getting into the details of the language of the bill. We'll certainly have time for that if this advances to the floor. I just think it's a poorly derived, or it's just a bad concept. People should be held accountable for their own actions. Our country is built on the notion of hard work and personal responsibility, not shifting responsibility from one party to another, either because they have deep pockets or because it will apply significantly more pressure, which I think is what the point is here. If we go ahead and harm the general contractor, that somehow is supposed to result in a solution. The general contractor in this scenario didn't do anything wrong. They should not be punished. So I'll be a no today, Madam Chairman. Thanks.
Thank you. Representative Mastro Francesca.
Thank you, Madam Chair. To Senator Sampson's point, I did have just a question for clarification on lines 12 through 14, where it exempts home improvement contracts. And in the line there, it says that if it's owner-occupied residence. Does that mean that a landlord who does not live in the, say, two-family home that he has, or one family, he does not live there?
Well, I'm seeing that Senator Sampson would like to answer this question.
I just wanted clarification on exactly what
We'll
that
get you that
means.
clarification. I don't have an answer for you right now.
You do?
I don't. If you want to pause the meeting, I can get an
If you
answer.
can, thank you.
Sure. Thank you, Madam Representative Mastro Francesca. It's noted here, a one-family or two-family dwelling is exempt.
Okay, that I understand. I just wanted to know that it says that it's owner occupied.
But that's a separate clause. It says owner-occupied residence of the property where such residence is located, or the construction or renovation of a one-family or two-family dwelling unit. So in your question, you noted that would the person who's not living in the two-family home
Or the one family.
or the one-family home, would that mean they had to live in that? But if you look at the next the next phrase there on line 15, it exempts one-family and two-family dwelling units. It does not qualify that they have to be owner-occupied.
Okay, thank you for the
course.
clarification.
Other comments or questions? Senator Sampson.
Sorry for the second time, Madam Chairman. I just wanted to ask very briefly, since we're talking about this language, it seems to me that this phrase that is in line 12 and 13, the construction, renovation, or rehabilitation of an owner-occupied residence or the property where such residence is located, I think that was intended to cover single-family residences, but it sounds to me like this would apply for a 100-unit apartment building. Since we carve out one and two families in the very next section, starting on line 14, it seems to me that you could have someone who resides in a large apartment building, as long as they are owner-occupied, that they would be carved out of this bill. Am I correct about that? Through you?
That is not the intention. I believe that the intention is to include in this bill large apartment complexes. So if there needs to be any further clarification, but clearly the intent is to include those buildings. Senator Sampson.
Thank you. Just one other question, which is when we say owner occupied, is there a time frame or specification about when the owner must occupy it?
That is not articulated in the bill. I don't see that in the bill, but I believe the intent is that the owner of that property has to live there at the time that this violation occurs. Or the renovation, I should say, because it's not a violation if they're occupying that residence.
Thank you very much for that answer, Madam Chairman. I have nothing further.
Any other hands? I see no other hands. Oh, Representative Weir.
Thank you, Madam Chair. In addition to the questions brought up by my colleagues, I wanted to go towards the last page, or I guess page 4, lines 82 through 100, the underlined section of the bill. And I do have a question on the, right around line 85, where it talks about the, I guess it starts at line 84, that an employee or labor organization representing the employee may bring a civil action under this section against either the subcontractor or contractor. Do you know why they can't do that now? Why is that not allowed now for an employee to bring a civil action if there's a dispute about wages?
We'll pause for a moment, and I will check with our LCO and OLR. Back on the record, currently, the employee could bring a suit against the subcontractor, but this clarifies, this requires, it allows them to bring a suit against both the subcontractor or the contractor, or both.
Thank you. So, okay, it just seems to me, well, that was the opinion of our legal team, I get it, but it seems to me that currently, if an employee had an issue, well, maybe that's a different situation. If they were injured, perhaps may be different than failing to get a paycheck. So thank you for that answer. Madam Chair, in the area of, if we're talking about civil action, why did we not have this go through the Department of Labor? Or, why are we bringing in a civil, and why are we bringing this into court rather than having this reside with the Department of Labor?
What we're doing here is giving this intent of this piece of legislation is to make the contractor responsible as well as the subcontractor. And so I believe that they have the option of either going through the Department of Labor for a wage violation, but this specifically allows them to also go into the court for that adjudication. Gives them that private right of action.
Okay, thank you. And I think my final question, as I can tell, will lie with, if the labor organization representing the employee can bring a civil action against either the subcontractor or the contractor, is it typical for it seems to me the labor organization would have to have access to pay records in order to verify or validate. Is it typical that a labor organization has access to employee pay records, whether through the employee or the employer? I'll try. Yeah, so is it typical, it seems to me that in order to bring a suit for unpaid wages, the labor organization is going to have to be able to validate that and verify that, before they're going to go to court, they're going to verify, yes, this employee wasn't paid. Is it typical for a labor organization to have access to employee pay records?
I believe that they are not required to have the payroll records if they have an employee who says they haven't been paid. I don't think that means to sue. They're not required to have the employer's payroll records. They might get them through a lawsuit.
Okay, so currently, so we're not asking some level of validation or verification. At any time, if an employee says, I haven't been paid, the labor organization could choose just to take his or her word without validating that and bring a suit against the contractor, as I understand it?
I think this is a theoretical question that probably never happens in reality because there's an expense to going to court, and it's a pretty substantial expense. And so I would think that there would be more than just a frivolous lawsuit brought. But, you know, technically speaking, we know that in all realms of the law, there can be frivolous lawsuits for a lot of different reasons. I assume that you can't say that someone can't bring a lawsuit unless they have the employer records. I think that would undermine the intent of this, which is to give those workers who feel there's been a violation of the labor laws in our state the opportunity to seek redress in the courts. I don't think that, I can't imagine that this would result in a lot of frivolous lawsuits.
Thank you for that answer. And so in summary, this would do two things, well, at least two things. It would allow the contractor to be liable potentially for actions of the subcontractor, which today, in current law, only the subcontractor is liable. And two, it would bring the labor organization, it would add them potentially as a party to the lawsuit or to the claims rather than it just be the employee. Is that correct?
I believe that under current law, a labor organization could also bring an employee's case before the courts. I don't think that's the distinction we're making in this change in the law. The change that we're making is that that the liability is jointly and severally, and it can include the contractor, not just the subcontractor.
Okay, thank you for that.
Representative Canino.
Thank you, Madam Chair. And my colleagues did a great job of discussing the issue of, bringing in a third party and the unfairness with that. But I want to focus on the actual consequences when this happens. So under the section that we are amending here, Section 3172 of the General Statutes, if the employer establishes that the non-payment of wages was due to a good faith belief that the underpayment of wages was in compliance with the law, then the full wages are required by the court to be recouped, plus some attorney's fees. However, if that is not established, then double damages is actually laid out here in the statute to be required to be paid. So that's for some arbitrary or intentionally devious motive where someone is just not being paid. And so that is being committed by the subcontractor. And by saying that a contractor is jointly and severally liable, now we are saying that through no fault of their own, when this subcontractor, does not pay their employees for some arbitrary or unreasonable reason, not only are we holding them liable, but we're actually awarding double damages here. So whatever we assumed that originally the cost of this bill would be for the contractor, well, double that. That is very concerning and in no way encouraging of businesses to come to the state, new construction business to start in the state, or to want to do these types of jobs. Because not only are we saying that you're liable for this action, but you're liable for the arbitrariness and the unreasonableness of the action of your subcontractor. And not only are you liable, but we're going to charge you double as well. It really commits to the hostile business environment that we have created in the state of Connecticut. And for that and the reasons stated by my ranking members, I'm going to have to be a no today.
Thank you. Seeing no other hands, I will ask the clerk to call the vote.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 6, House Bill 5275, an act concerning a contractor's responsibility for unpaid wages on a construction contract. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez, Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No?
Representative Hall, Representative Hughes, Senator Lesser, Representative Canino,
No.
Representative Gauthier, Representative Gauthier, you're muted. Representative Master Francesco,
No.
Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you. We will be holding votes open. We'll move on to item number 7. This is House Bill number 5280, an act concerning a non-charge for employees' paid benefits through the shared work program during periods of high unemployment. JF to the floor. Is there a motion? Is there a second? It's been moved and seconded. Senator Sampson.
Thank you, Madam Chairman. Oddly, it appears the odd-numbered bills seem to be much more amenable. Without objection, we would offer this item for the consent calendar as well.
Thank you. We'll be adding that to the consent calendar. Moving on to item number 8, House Bill number 5276, an act concerning volunteer fire departments and definition of employer under the State Occupational Health and Safety Act. This is a J up to the floor. Is there a motion?
So moved.
It's been moved and it's been seconded. This is a bill that would bring volunteer fire departments under our State Occupational Health and Safety Act. Comments or questions? Senator Sampson.
Madam Chairman, we've had this bill year after year. The testimony, I thought, very clearly demonstrated that the bill's unnecessary. The towns that are operating under current law are doing just fine, and they don't need this change. So I'll be a no today. Thank you.
Any other comments? Seeing none, then I will ask the clerk to take the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 8, House Bill 5276, an act concerning volunteer fire departments and the definition of employer under the State Occupational Health and Safety Act. This is a motion to JF to the floor. Senator Kushner,
Yes.
Representative Sanchez, Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is no.
Representative Weir,
No.
Representative Hall, Representative Hughes,
Hughes votes yes.
Senator Lesser, Representative Canino,
No.
Representative Gauthier,
Gauthier, yes.
Representative Master Francesco,
No.
Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you. We'll be moving on to item number 9. On the agenda, House Bill number 5277, an act concerning the posting of veterans' information and services for display in the workplace. This is a J up to the floor. Is there a motion?
So moved.
Is there a second? It's been moved and seconded. Senator Sampson. We're on an odd number bill. No, I thought you were going to put it on the consent calendar.
Madam Chair, if I may.
Oh, okay. We're moving to Representative Weir.
Yeah, Madam Chair, we'd like to offer this up
I
for
see.
consent if it works for you.
Thank you. To the clerk, please add this to the consent calendar. Item number 10, House Bill number 5382, an act concerning the comptroller to conduct a study of health insurance coverage for retired police officers and firefighters. This is a J up to the floor. We heard testimony. Is there a motion?
So moved.
And a second? It's been moved and seconded. We did hear testimony about the concern of our law enforcement and firefighters about when they retire at a young age, younger than they are before they're able to collect or covered by Medicare. they are asking that we have a study to look at what opportunities might be there to bridge that gap from the time they retire until they're eligible. Is there any comment or question? Representative Weir.
Madam Chair, I understand what the bill does. It was concerning to me, and I'd be happy to be corrected, but I did not see any testimony from the comptroller on this bill. And here we're asking the comptroller's office, we're mandating that they perform a certain task without input from the comptroller's office. Is there a reason why they didn't testify, or is there testimony that I missed?
I don't believe there was testimony, but I will say to you, I will let you know that we often get commentary from the comptroller's office, and we have this session on other bills, so I'm assuming if they had an objection, they would have made it clear to us.
Thank you. I would like to see personally, for me, I will be a no on this. I would like to see the comptroller's office weigh in, as I have seen the comptroller's office weigh in on many of the other bills that we're touching upon. Thank you.
Thank you for that comment. I'm sure that there'll be an opportunity for you to have that conversation with the comptroller, and we can certainly facilitate that through our office if that's helpful. Senator Sam.
Thank you very much, Madam Chairman. I got to remember this one button doesn't seem to work. We've been back and forth on this particular policy. We understand that this is a study. We heard lots of very compelling testimony, heart-wrenching in some cases. I want to just state that I think that we're all sympathetic to the situation. It's a matter of whether or not we want to interfere with some level of local control, whether or not this is something that is going to impact local budgets. There's a lot of factors involved. The note that my colleague made about the lack of the comptroller's testimony or weighing in on this subject is another factor. But I don't want to offer it for consent after my colleague indicated he was going to vote no. Okay. I think that we're willing to work with the chairs to try and find a way to support this legislation going forward. So we would offer this item for consent as well.
Thank you. And I do think, just a little further commentary on it, I appreciate putting it on the consent calendar, but I do recognize that I think the comptroller might have some ideas about how they could be helpful. And I think the main issue will be ultimately whether or not the municipalities would be in a position to offer some kind of bridge health insurance program for those officers and firefighters. So I think this is something that is, I think all parties would be interested in seeing what the comptroller could come up with on this. So I appreciate the offer to put it on the consent calendar. Mr. Clerk, please add this to a consent calendar. And I do want to point out that it's an even numbered item on our agenda. We can have a little levity here today, right? Moving right along. Item number 11 on the agenda, House Bill number 5383, an act concerning the Legislative Commissioner's recommendations for minor and technical revisions to statutes concerning labor. This is a JF to the floor. Is there a motion?
Second.
It's been moved and seconded. Representative Weir. It's a House bill, I'm told.
Yes, thank you. Madam Chair, we would like to offer this up for consent if
Thank you.
so
We-
inclined.
Thank you. We'll add that to the consent calendar. Moving on to item number 12, House Bill number 5388, an act concerning processing fees for medical records for applications for disability retirement. This is a JF to the floor. Is there a motion?
So moved.
It's been moved and seconded. Are there comments or questions? Representative Canino.
Thank you very much, Madam Chair. So this bill, seemingly only a small change, only 2 lines really of text that we're adding here, adding the application for disability retirement benefits under the state employees retirement system to both Social Security Act claims and veterans benefits claims, which are held subject to this 65 cents per page limit that can be charged when requesting health records related to these types of proceedings. I want to give us pause here because anytime we limit a private business, especially a healthcare provider's ability to recoup necessary costs, earnest costs that are incurred on that employer for reasonable things such as furnishing records, double checking records, making sure legal compliance is in order, making sure HIPAA is complied with. I mean, those lawyers are not cheap. When we prevent our businesses from being able to reasonably recoup those costs, we're hurting them, and when we're hurting the employees that they employ. When our businesses lose money arbitrarily, they're not allowed to hire new employees, and when the state stacks cost after cost after cost on our businesses, they end up closing or they end up not coming to this state. And that ends up contributing to what we've seen happen in Connecticut. I mean, we talk all the time about healthcare in the state and about how it's unaffordable and there are a lack of independent practitioners. Everyone always rails against how, Hartford Healthcare and a couple of the other organizations, these massive organizations are coming over and taking control. But they're the only ones who can eat these cost burdens. Who's going to be more likely to absorb this cost? A giant healthcare network or your local pediatrician or APRN that is fighting every day to survive, that is on the phone doing insurance regulation, dealing with insurance regulations and compliance, and is seeing their administrative costs rise year after year after year. This is a giant unfunded mandate on our medical offices. It is not fair. And I've heard from medical offices in my district and from across this state that if this were to be put in place, we would definitely see their administrative costs increase. And I understand what we want to do here. We want to make life a little bit easier for someone who's doing this application. But I fear what we're doing is going to be broadly impactful on the healthcare environment writ large when we're just placing another administrative burden on these these small, oftentimes small businesses who are just fighting to stay alive day in and day out in the business climate that we have created for them in the state of Connecticut. And with that, I will be a no today. Thank you.
Any other comments, questions? Seeing no hands, I would ask the clerk to call the roll.
A roll call vote has been requested and a motion duly made and seconded on Agenda Item 12, House Bill 5388, an act concerning processing fees for medical records for applications for disability retirement. This is a motion to JF to the floor. Senator Kushner.
Yes.
Representative Sanchez. Senator Cabrera. Representative Wilson.
Yes.
Senator Sampson.
Sampson is no.
Representative Weir.
No.
Representative Hall. Representative Hughes.
Hughes votes yes.
Senator Lesser. Representative Canino.
No.
Representative Gauthier.
Gauthier, yes.
Representative Mastro Francesco.
No.
Representative Shake.
Yes.
Thank you, Madam Chair.
So we will be holding votes open, and give me one moment. Back on the record, we're going to check, and if you have any information, I think all your members are here, right? Yes. Okay. We're checking on the amount of time people would need to have to hold votes open. But before moving on, we do need to vote on the consent calendar. So I would ask the clerk to call the consent calendar.
A roll call vote has been requested and a motion duly made and seconded on the consent calendar consisting of the following items. Item 2, Senate Bill 271, an act implementing the recommendations of the Labor Department. Motion to JFS to the floor, LCO 2772. Agenda Item 3, Senate Bill 346, an act concerning the modifications to the Governor's Workforce Council. JF to the floor. Agenda Item 5, Senate Bill 349, an act concerning modifications to the Firefighters Cancer Relief Fund. JF to the floor. Agenda Item 7, House Bill 5280, an act concerning a non-charge for employees' paid benefits through the shared work program during periods of high unemployment, JF to the floor. Agenda item 9, House Bill 5277, an act concerning the posting of veterans' information and services for display in the workplace, JF to the floor. Agenda item 10, House Bill 5382, an act requiring the comptroller to conduct a study of health insurance coverage for retired police officers and firefighters, JF to the floor. And agenda item 11, House Bill 5383, an act concerning the legislative commissioner's recommendations for minor and technical revisions to statutes concerning labor, JF to the floor. Senator Kushner,
Yes.
Representative Sanchez, Senator Cabrera, Representative Wilson,
Yes.
Senator Sampson,
Sampson is yes.
Representative Weir,
Yes.
Representative Hall, Representative Hughes,
Hughes votes yes.
Senator Lesser, Representative Canino,
Yes.
Representative Gauthier,
Gothier, yes.
Representative Mastro Francesco,
Yes.
Representative Shake.
Yes.
Thank you, Madam Chair.
Thank you, and we will be holding votes open. Before we recess, I'll make an announcement on how long we'll be holding votes open. I would like to announce that there will be a public hearing on Tuesday, March 10th, and the next meeting of the Labor and Public Employees Committee will be on March 12th. It says here at 12 a.m., but I'm pretty sure it's 12 p.m. 12 p.m. in hearing room 1C. But I will give our members an opportunity to respond to see how long we need to hold votes open. We will be holding votes open until 3:30 p.m., at which time we're now in recess, but we will adjourn the meeting after 3:30 p.m. Thank you all. We'll see you next week. See you.
One moment, Representative Gothier.
Representative Gauthier, I believe I'm missing your vote on agenda item 6.
Can you just say the title?
Yep, that is House Bill 5275, an act concerning a contractor's responsibility for unpaid wages on a construction contract. JF to the floor.
Yes.
Thank you.
Thanks.
That's all the outstanding votes I have from you. Thank you.
Thank you.
Hello, Senator Cabrera, can you hear me?
Yes, how are you?
Good, and you?
I'm well.
All right, so let's see. We have, do you want me to just go in order and then skip over the consent calendar and then do that last, or just go
Yeah,
one
that's
by one?
fine.
Okay,
Order
okay.
and consent is fine.
All right. So the first one was SB 268. That is an act authorizing the comptroller to withhold payments for violating the prevailing wage statutes.
Senator Cabrera votes yes.
All right. The next one is skipping over to SB 347 because of the item number 2 and 3 are on consent calendar. So item number 4, SB number 347, an act increasing the threshold amount for felony unemployment compensation fraud. And this is the JF to the floor.
Senator Cabrera votes yes.
Right, next one is HB 527 or 5275, item number 6, an act concerning contractors' responsibility for unpaid wages on a construction contract. JF to the floor.
Senator Cabrera votes yes.
Next is item number 8, HB 5276, an act concerning volunteer fire departments and a definition of employer under the State Occupational Health and Safety Act. And this is the JF to the floor.
Senator Cabrera votes yes.
Next is all the way down to item number 11, HB 5383, an act concerning the Legislative Commission's recommendations for minor and technical revisions to statutes concerning labor. JF to the floor.
Senator Cabrera votes yes.
All right, now it's for the consent calendar. This is for items number 2, 3, 5, 7, 9, 10, and 11. Which are as follows: consent calendar to SB 271, an act implementing the recommendations of the Labor Department, and that would be a JFS to the floor LCO 2772. Next would be SB number 346 on the consent calendar, an act concerning the modifications to the Governor's Workforce Council, JF to the floor. Item number 5, SB number 349, an act concerning modifications to the Firefighters Cancer Relief Fund, JF to the floor. Item number 7, HB number 5280, an act concerning non-charge for employees pay benefits through the shared work program during periods of high unemployment. That is a JF to the floor. Item number 9, HP number 5277, an act concerning the posting of veterans information and services for display in workplace. JF to the floor. Item number 10, HB number 5382, an act requiring the comptroller to conduct a study of health insurance coverage for retired police officers and firefighters. JF to the floor. And lastly, item number 11, number 5383, an act concerning the legislative commissioner's recommendations for minor and technical revisions statutes concerning labor. JF to the floor. These are all on consent calendar.
Senator Cabrera votes yes on the consent calendar.
All right, so you're all caught up in all the votes.
Thank you very much. Have a good day.
Yep, you too. Thank you.
All right, bye.
Good afternoon, Senator Lesser.
Good afternoon.
All right, so let me get your votes. So there was a consent calendar for item number 2, 3, 5, 7, 8, 9, and 10, 8, 9, 10, and 11, and the rest were voted on. Do you want to go through one by one? And then go to the consent calendar last?
Sure. I can also tell you I'd like to vote in favor of all the items. Can you do that? Is that
Oh, yeah, I can. Yeah, that works. That works for me.
okay? All right. Thank you.
All right, thank you. Good afternoon, Representative Hall.
How's it going?
Oh, good, and you? Okay.
Good, good, good.
All right, so. Out. So it's gonna go in order. There was a consent calendar, so I'll just skip over those and come back to that at the end, if that's all right with you.
That's fine.
All right, so the first bill, item number 1 was SB 268, an act authorizing the controller to
Yes.
withhold payment. All right, yes, that's the J at the floor. Good. Next one is item number 4, SB number 347, an act increasing the threshold amount for family unemployment compensation fraud. That's JF to the floor.
Yes.
Next one is item number 6, HB 5275, an act concerning a contractor's responsibility for unpaid wages on a construction
Yes.
contract. JF to the floor. Next is item number 8, HB 5276, JF to the floor, an act concerning volunteer fire departments and the definition of employer under the State Occupational Health and Safety Act.
Yes.
Next is item number 12, HB 5388, an act concerning processing fees for medical records for applications for disability retirement.
Yes.
And now we're going to the consent calendar.
Yeah.
That one is just yes to it.
Yep.
All right, perfect. That works for me. Thank you.
Sounds good. Thank you.
Yep, take care.